Good afternoon, and thank you for joining us today. Josh Mandelbaum is our speaker. He is a staff attorney in the Environmental Law and Policy Center, Des Moines office. He works on clean energy, transmission reform, clean water litigation, and policy issues. He previously worked as a litigation associate with Layden Waterman in Davenport, Iowa, and before law school, Josh worked for 4 years as senior policy advisor for Iowa Governor Tom Vilsack. Thank you, Josh.
Thank you. So today's CLE is meant to be a high-level overview of the Clean Power Plan with a little bit of specific Iowa color. And I wanted to start by giving a little background on the Environmental Law and Policy Center and what we do, because we're not viewpoint neutral, and that might color my presentation a little bit, and I want to make sure that you have that perspective out front. And so the Environmental Law and Policy Center is a Midwest-based public interest environmental advocacy group, and we work on a range of legal and policy issues and engage on a variety of campaigns, including work on the Clean Power Plan. So we're an organization that is supportive of the Clean Power Plan, and we certainly want to see it successfully implemented. So I come to this presentation with that background. But I wanted to give a little bit of an overview in terms of how I've structured the presentation and where we're going. And so I wanted to start with what led to the Clean Power Plan. And I haven't really said exactly what the Clean Power Plan is. And the Clean Power Plan is EPA's rule regulating and establishing standards for carbon pollution from existing power plants. And we'll give a little background in terms of how it came into being, and then we'll go through the structure of the rule, the emission reduction goals and how those were developed, as well as the compliance piece of the rule. And it's really, I think, the compliance section that is where the most interesting discussion and most relevant discussion will be, because there are a lot of issues to consider and a lot of options for states and stakeholders to mull through. And so that's really where I think the most interesting discussion will be. And then for those of you who've roughly followed the Clean Power Plan, there has been a lot of litigation and some interesting legal developments. And I'll try and discuss thoughts on what the implications are of the litigation and those legal developments. I also wanted to, before we start, give some credit. So a number of the slides, particularly as I go over the structure of the rule and the state compliance options, a number of those slides were provided by the Department of Natural Resources, and they used those slides in one of their stakeholder meetings, and I thought that would be a useful way to provide overview. So some of those slides have a little more information than might be needed, or a little different context, but I wanted to at least credit DNR here since it's not clear that those slides were necessarily from DNR. So what led to the Clean Power Plan? And the Clean Power Plan didn't exist in a vacuum. And there are a number of items that are worth talking about, including the overall framework to the Clean Air Act, and then how the Clean Air Act was used by advocates and litigants to establish overview over carbon pollution. And so there's some key litigation as well as some subsequent action by EPA that are all part of the foundation that led to the Clean Power Plan and are pretty important to understand when you put this in context, because there's ongoing litigation about the rule that came out, but when you have the context, it becomes, I think, pretty clear that even if the Clean Power Plan goes away, something similar will eventually take its place. And that's, I think, important when you're advising clients or you're working for businesses and thinking about how you respond to a standard like the Clean Power Plan. So at a high level, the key language comes from Section 108 of the Clean Air Act, and that requires EPA to regulate any air pollutant that can reasonably be anticipated to endanger public health or welfare. Further, the Clean Air Act requires the EPA to identify categories of sources that contribute to air pollution. And power plants have been one of those sources from pretty much the beginning. So it was listed in 1971. And then Section 111D is actually the section that the Clean Power Plan is under, and that directs development of emission standards for pollutants from existing sources in those listed categories. So the structure essentially, once there is an endangerment finding for a pollutant, and that pollutant comes from a listed source, EPA has to develop emission standards for that source and that pollutant. And that's sort of where you get to the key court cases, because carbon pollution and other greenhouse gases weren't initially listed in the Clean Power Plan. So it was one of those pollutants that the EPA administrator potentially had authority for. And there were advocates who for many years thought that the EPA should be regulating greenhouse gases. And after a number of years of inaction, there were several states that petitioned EPA to regulate carbon pollution from motor vehicles. And that's the Massachusetts versus EPA case. And that's where the court held that the Clean Air Act did in fact apply to greenhouse gas emissions. That didn't in and of itself lead to any regulation, but it did require EPA to make a determination on that key language, whether greenhouse gases can reasonably be anticipated to endanger public health. There are a couple subsequent cases that have essentially reaffirmed this finding. So AEP versus Connecticut was dealing with federal common law claims. So again, there were a number of states that brought action and seeking, in the absence of carbon pollution standards, to use federal claims to get some action and to get recourse. And there, the Supreme Court held, essentially affirming that the Clean Air Act does apply to greenhouse gases, but also that the authority under the Clean Air Act essentially preempted those federal common law claims. Interestingly, it did not explicitly preempt state common law claims, and there was a subsequent case in Iowa, Freeman versus GPC, that made clear that state common law claims were not preempted by the Clean Air Act. And there's, I think, pending litigation on different pollutants over in Muscatine based on that. And then the UARG versus EPA is another example where, again, the Supreme Court affirmed the central finding of Massachusetts versus EPA that the Clean Air Act general definition of air pollutant included greenhouse gas emissions. But there, it was really over a question of whether or not air pollutant meant the same thing in every use of the term throughout the Clean Air Act, and it gave EPA some discretion there. So after it was clear that greenhouse gases could fall under the Clean Air Act, what was necessary was an endangerment finding, and that came in 2009. and EPA relied on a significant amount of science from the Intergovernmental Panel on Climate Change, the National Resource Council. There's a significant number, the U.S. Global Climate Research Program, and those were the basis of the administrator's endangerment finding. It's a lot of the standard concerns that you hear about climate change, from the effects of temperature change, effects on air quality, extreme weather events, climate-sensitive diseases, effects on agriculture, water resources, energy use. And it's a fairly detailed document, but the key piece is that finding was litigated and then upheld. And so it was upheld by the Federal Circuit, and the Supreme Court denied cert on that. So that sort of background and combination sort of meant that Section 111D could be applied, or needed to be applied, to address greenhouse gases and carbon pollution. And a few key pieces of the Section 111D framework. So the emission standard must reflect what's called the best system of emission reduction. And we'll get into what EPA found the best system of emission reduction to be in this case. But this is also a cooperative federalism statute. So the best system of emission reduction sets the emission goal, but then it's left to the states to figure out how to comply with that goal in target. And that the state plan has to provide mechanisms for enforcement. And if the state fails to act, EPA has the authority to provide a federal plan that would be implemented in the absence of a state plan. So I'll spend a little bit of time going through the best system of emission reduction. I don't want to get into too much detail. That's the framework. I think the more interesting part is, again, on the compliance side. But what EPA did is it looked at power generation throughout the country and essentially broke up the country into three regions. An eastern interconnection, with the interconnection is a reference to the electric grid and the interconnected nature of the grid. The western interconnection, and essentially Texas, which operates on its own and uses a very large amount of electricity. And then EPA developed what they called building blocks that they looked at the regional level. And in the draft plan, there were 4 building blocks, but in the final plan, there were 3 building blocks, and those are all how you can reduce the emissions. So one piece was a heat rate improvement, so improving essentially the efficiency at the power plants. The other was essentially reducing the amount of time that those power plants would run, either by increasing the dispatch of existing natural gas combined cycle plants, which have significantly less carbon pollution than coal-fired plants, or adding new utility scale renewable generation. And so EPA determined, based on the mix of the resources that existed and the technical potential of these sources, what the best system of emission reduction was based on that. So a little more detail, although I won't spend too much time. The heat rate improvement, that's going to be different based on the power plants and what level of efficiency that they're already running on. And so it's slightly different based on the interconnection. And the eastern interconnection, where Iowa has actually the highest calculated heat rate improvement. The next piece was shifting generation from fossil steam to existing natural gas combined cycle plants. Every power plant runs a certain amount of time, and in this building block assumed that natural gas plants would pick up the slack and run more frequently. One of the interesting pieces in terms of the way this works, Iowa is, in terms of fossil fuel generation, has a lot of coal plants, not a lot of natural gas. So this building block maybe has a little bit less impact on a goal for a state like Iowa. And then the third building block was shifting to renewables. And this building block changed pretty significantly between the draft rule and the final rule. So in the draft rule, this was based on, EPA based this on a region's RPS. So it looked at, and an RPS is a renewable portfolio standard. So some states have aggressive renewable energy goals. And EPA thought, well, if the state has those goals, they're going to get that energy and that can go into the best system of emission reduction. But then there's some states that have significant renewable energy potential that don't have particularly aggressive renewable portfolio standards, or might not have a renewable portfolio standard at all. And it sort of skewed the targets as a consequence. So in the final rule, EPA changed the renewable generation and made it based on the potential renewable energy in a state. So if you have a good wind or solar resource, that became the basis. And that actually shifted things for Iowa pretty significantly, in part because Iowa has a 105 megawatt renewable portfolio standard. Some of our neighboring states that have very good wind resources, Nebraska, the Dakotas, don't really have any renewable portfolio standard. And we're all averaged in a region. And then another piece that frequently was talked about, and if you're following some of the conversation about the Clean Power Plan, was the fourth building block, which was taken out in the final rule, and that was demand-side energy efficiency. And I think a big part of why that ended up being taken out had to do probably with legal strategy, because demand-side energy efficiency is outside of the fence line. While it impacts how much a power plant runs, it's not directly controlled by a utility, like utility scale renewable generation might be, or the other power plants. The energy efficiency and the important distinction, the way you calculate the goal and the key pieces of the goal does not limit what a state can use to develop compliance. So energy efficiency, while it's not part of the best system of emission reduction, it's something that the state can take advantage of when crafting their compliance plan. And there's actually been some amount of confusion over conflating the building blocks with the actual potential compliance. So you put this together, and this is just sort of a high-level look at the formula. You look at the emission performance rates and the generation mix of the state, and that gives you a pounds per megawatt rate. In Iowa, the final goal is 1,283 pounds per megawatt. The goal is also translated into, it's not just a rate-based goal, it's just a mass-based goal, and that's the number of tons, and that's roughly 25 million tons. I'm not going to spend a lot of time talking about the affected units, but I do want to, at least the standard for the affected units, I do want to just show you what these affected units look like. So these were identified as the affected units in Iowa. It's predominantly the investor-owned utilities, Mid-American, and Alliant, Interstate Power and Light, although there are some municipal utility and rural electric cooperative units. A key piece, and we haven't talked about this, these goals are set from 2012 emissions. And we're obviously several years beyond 2012 now. And by the time we get to the end point of these goals, there are things that are already in place from a planning perspective, unrelated to the Clean Power Plan, that will be impacting a number of these units. So for example, Neil 1 and 2 up in northwest Iowa are scheduled to retire. On the other side of the state, IPL plant in Dubuque has a couple of units that are scheduled to retire. Ames Electric, there are a couple of units there that are converting from coal to natural gas, as well as the Sutherland, the Prairie Creek, and Burlington all have units that are either retiring or converting to natural gas. And since those actions are subsequent to 2012, those are all pieces that will essentially automatically be a part of Iowa's compliance plan, because they'll reduce our emissions and they'll help the state comply. And as I mentioned, the goals can be computed both from a rate perspective and a mass-based perspective. This slide simply lays out what those goals are. One of the key comments between the draft rule and the final rule, there was concern about the implementation timeline, and the final goal, that rate of 1,283 pounds per megawatt, is a 2030 goal. And there are interim goals, but those interim goals don't kick in until 2022. And this timeline is actually pretty important when we get to a later part of the discussion about the litigation and the impact of the litigation and the stay, because this rule is a pretty far out timeline and a significant amount of time to comply. Another piece to note is the mass-based goal. There are two different mass-based goals here. One is just for existing units, and then EPA did a separate goal that allows for additional growth. It's a slightly higher goal. If a state does a plan with existing units plus what they call a new source complement, and that would incorporate any new units. In Iowa, that would be something like including the Marshalltown natural gas plant that IPL is in the process of building, but that isn't online. And the state has discretion about whether or not to choose to have the Clean Power Plan apply to just existing sources or existing plus new sources. And there's some requirements that go along with either selection. We've got a few slides that just demonstrate the stringency. And the red line is really what you want to focus on. The blue line was the draft rule. The red line is the final rule, and that's the target. Iowa's goal is the 9th least stringent in the country. And as we've already mentioned, there are a number of actions that are already in place that make Iowa well on its way to meeting its goal. This is Iowa's goal put in context of its rate-based goal and the interim compliance to the final compliance. It also has where we started in 2012. This is just a slightly different way to look at that. And this is the mass-based goal. And one of the key pieces, there were a number of retirements that we talked about that were yet to occur. The ones that I mentioned were all forward-looking retirements. There are a number of retirements that have already occurred. And while Iowa had 38 million tons of carbon pollution in 2012, in 2015, we were around 32.5 million tons. So we've already come down significantly, which again, what they call this glide path to meeting the targets, we're already sort of gliding down that path without a concerted plan. And this is the timeline for what the state has to do to comply. And some of this we'll get to in the litigation. There was an initial state plan. Some states were going to make their final plan with the initial plan, but there was an option to ask for additional time, which Iowa was planning on doing. And there were requirements for that proposal. The stay that we'll talk about later is effectively made that filing null. Those filings aren't going to happen. The final plan submittal is not due until the fall of 2018, and we'll get to what the implications might be for that when we talk about the stay. But the final plan wouldn't be submitted till 2018. The first compliance target is in 2022. So there's a significant window between the compliance, the filing of the plan and actual compliance. And then what the states have to do to comply, there are a number of plan pathways. I'm not really going to talk about the state measure plan. That was essentially included in the rule primarily for California, so it's not particularly relevant to Iowa. But these are the pathway options, and this chart's a little tough to read, but we'll get into some of these in a little more detail. But the first key issue is the mass versus rate, and a state needs to decide if they want a mass-based approach or a rate-based approach. So which target or which goal they're going to meet. And then within those plans, there are a number of different decision points as well, and this highlights some of them. So for example, on the mass side, we were talking earlier about whether or not you incorporate new sources, and that has an impact on the goals. And then if you don't include new sources, there are requirements to address what's called leakage, to make sure that the emissions that you're reducing from existing plants aren't being shifted to new sources. And then there are a whole range of issues that come into play under a rate-based plan, and we'll get to that a little bit. So the general way that a rate-based plan works is each source or power plant has to meet the standard set by the rule, the pounds per megawatt hour standard. If the source can't meet that, then they have to acquire what's called ERCs, emission rate credits, to bring their pound per megawatt average into compliance. And they can acquire those ERCs either by trading or by actions that the utility who owns that power plant takes themselves. And the key there is what counts as an ERC, and what can be used there. And that is that's significantly broader than what was in the best system of emission reductions. So renewable energy can be counted as part of the ERC, but it's not just the renewable energy that was part of the utility scale, large wind farms, large solar farms. It could also be distributed generation, so the solar that's on rooftops and scattered throughout the grid. It can be what's called combined heat and power and waste to energy. So if you're a large industrial customer and you have a lot of waste heat, you can capture that energy, and that can be used as a potential means of generating emission reduction credits. Energy efficiency, which that's the demand side piece that that was taken out of the best system of emission reductions, that can be used to generate emission reduction credits. So there are a lot of things and a lot of flexibility in terms of what can be used to generate credits under a rate-based system. Another interesting piece about that is a timeline-related piece. So Iowa has energy efficiency plans that exist today, and a number of those energy efficiency measures produce savings over a lifetime of the equipment. So you could install something in 2017 and it can be generating efficiency savings potentially in the compliance period in 2022 and beyond. The key and the challenge is verifying that those savings exist and that they're real. And that has to do a lot with what goes on the back end to allow the state to take advantage of energy efficiency in the plan. I'm not really going to discuss this, but this is just a way to demonstrate the calculation and how you would meet a rate-based goal. So there's and in the denominator where you have the energy output and the ERC, it's getting enough of those ERCs to get the ratio down. And that's just a mathematical representation of what that looks like. So in some respects, a mass-based plan, a mass-based approach can be seen as simpler. You just have a number and you know what that target is, and you have to reduce the emissions to the number of tons. There are some issues that get complicated under a mass-based plan. So each power plant or owner of the power plant is going to have a sufficient number of allowances, emission allowances, that they comply. The allowances cover what they're actually polluting. And allowances can be traded or banked, and then the state compliance plan determines how the allowances are initially allocated. So this is sort of an illustration of where we're at from a mass-based approach to where we need to go. So if you look at the left side of the chart, that's the historical emissions in the state. And where we're at today, a little over 32 million tons of carbon pollution. And in a little over half a decade, during the first compliance period, our initial goal is 31.7 million tons of carbon pollution. And this just lists out some of what I was talking about, the steps that are already going to take place that utilities already have planned in terms of retirements and conversions that will take place during that period. So it's anticipated that those retirements and conversions will take us a significant way towards meeting the goals in Iowa, those pieces alone. So the question is, what are some of the key decision points in terms going forward that we need to be thinking about as a state? And this is where different stakeholders are going to have different perspectives on a number of these issues. And this is sort of the crux of figuring out what a state plan is going to look like, is coming to some resolution on a number of these issues. And the utilities might have a different interest than environmental advocates, but they also might have a different interest than some of their customers and some of the large power users who certainly have a stake in this as well. So when I put the slide out, the first slide was, and the first decision point is the rate versus mass-based approach. And there are a number of factors to consider there. So the ease of compliance is certainly one, and that I don't think the Clean Power Plan will be particularly difficult from a statewide perspective to comply with, but it might be a little difficult for some of the utilities, particularly the smaller utilities have different challenges. There's also how some of our resources factor in. From a mass-based approach, you have to limit the total mass emissions. On a rate-based approach, there's a possibility that you could do things to generate a sufficient number of ERCs that you wouldn't necessarily need to change the overall amount of emissions as much. So for example, you can generate ERCs by building more wind or by doing more energy efficiency, although both of those would in theory reduce Iowa emissions. Our grid is interconnected and could end up that Iowa can continue emitting while meeting a rate-based target in that way. From our perspective, there might be different environmental benefits, in terms of overall emission reductions. It's possible that under a rate-based approach, you could offset if you generate more wind energy that generates ERCs or significant amounts of energy efficiency. You could have a greater environmental benefit because you're offsetting more fossil fuel use. One of the things we haven't talked about yet, but the ability to trade is, I think, a really important factor, and that can impact the ease of compliance. It can impact the cost of compliance because trading with other states and that either generate allowances or ERCs would allow a state to pursue the least cost alternative, and that might not be within the state's borders. This is, and I've got a separate slide on trading, but this matters because mass-based states can only trade with other mass-based states under the rule, and rate-based states can only trade with other rate-based states. So if you care about the ability to trade, the rate versus mass-based decision takes on an additional importance. And that also applies from an economic impact perspective. Iowa has a tremendous opportunity. We're a state with a very good wind resource, and that wind energy can be used to help a number of our neighboring states comply with the Clean Power Plan. And then another thing to consider is what's next. If you assume carbon pollution regulation is not going away, the Clean Power Plan or whatever is only the first step. And from a long-term planning perspective, it's worthwhile to think about how the decisions we make today will impact future compliance. I mean, that's one of the significant challenges that we're dealing with is decisions in power generation planning that were made years ago have an impact on how we can respond to the Clean Power Plan today. And decisions that we make today will have an impact on how we deal with these issues in the next iteration of carbon pollution standards. So I talked a little bit about trading. And trading can make compliance cheaper. It could allow Iowa to help other states comply, but it will really be driven on the decision in terms of what Iowa chooses and what other states choose. And I think that'll be a factor that weighs in to how Iowa approaches the Clean Power Plan and should be something that when you're taking a global view, Iowa thinks about. For those interested in trading, EPA has drafted model trading rules, and it's anticipated that those will be finalized sometime this summer. Another piece on the compliance side is what I call Iowa's wind advantage. And one of the things that we talked about when we looked at those timelines was a number of actions that have been taken since 2012 that will help the state with compliance. And wind is another example of that. So right now, Iowa has approximately 6,200 megawatts of installed wind capacity. There are another 800 or so megawatts that are anticipated to be completed by the end of the year in terms of what's already announced. And that represents a significant component of our energy. We're up to 31% of the state's generation, and that leads the country in terms of percent. You go back to we're not the overall leader in terms of the amount of wind energy installed. That would be Texas. They have 2.5 times that 7,000 megawatts, but it's a very small percentage because Texas is not a very small percentage, but a much smaller percentage because Texas is a much larger energy consumer. But the other piece, when policymakers are thinking about this, that wind represents a significant economic development opportunity and investment in the state. There have been $10 billion invested in these projects to date. There are ongoing lease payments that go to rural property owners that agree to house these wind turbines. It increases the tax bases of these communities. So it has a significant impact on the entire state and our economy, which is, when you're considering compliance options, not something to be taken lightly. And wind helps under either a mass-based or a rate-based approach. Under a mass-based approach, the more wind you have, that offsets the need to run other generation sources. So there will be less running of coal plants, potentially less running of natural gas, and less emissions as a consequence. Under a rate-based approach, wind generation can create ERCs, the emission reduction credits. And not only that, but it creates ERCs. Anything that was installed post-2012 creates ERCs. So Iowa has had, I think, of that 6,200 megawatts of wind, a little over 2,000 of that has been installed post-2012. And as long as those turbines, which have a much longer life cycle than the compliance period, so the turbine installed in 2013 will be running in 2022 and beyond, as long as it's producing energy, it's going to be generating ERCs during that time frame. And then another piece to consider, at the end of last year, in the federal omnibus appropriations bill, the production tax credit was extended. And there was a 5-year extension with what's called the phase out. So the production tax credits have, there have been some concern of folks who don't like tax credits for renewable energy. And there's been debate on that. Rather than a 1 or 2 year extension, the agreement reached this year was a 5-year extension with a phase out, where the first couple of years it's the full production tax credit with a 20% decline over the next several years. So in 2019 it'd be 40% of the credit this year. But that also makes wind as a compliance option, wind that is built when it can take advantage of the production tax credit, significantly cheaper. I would guess that what we'll see is we'll see some projects announced in Iowa over the life of the production tax credit designed to take advantage of that. I think the question is how much wind and what that does to our compliance. But not only that, you could see a lot of wind built to help other states comply. And if that wind is built in Iowa, that goes back to the economic advantage that it provides, as well as some benefit to Iowa energy users. And decisions that we make in terms of our compliance plan will impact how that plays out. Also want to talk about energy efficiency, and there will be a question about how we use energy efficiency. The interesting piece about that is we already do energy efficiency. State law requires all the utilities to have energy efficiency plans. The investor-owned utilities, Mid-American and Alliant, have plans that are reviewed by the Iowa Utilities Board. And the consumer-owned utilities, the municipal utilities and the electric co-ops, are still required to have plans and submit them to the board, but there's not the same level of oversight. But certainly it seems like we're investing in energy efficiency. That's something that we can include in the plan. The question is, do we have potential for more aggressive energy efficiency? Energy efficiency is one of those compliance pathways that it allows the customers who implement energy efficiency to lower their bills while helping everyone else comply. And we think that makes it a very attractive compliance pathway. And there are a number of things to consider to make sure that we can take full advantage of that. Some of it is, what do we need to do from an evaluation, measurement, and verification to make sure that we can get credit for the programs that we have existing. And Iowa's been fairly forward-looking. We're in the process of taking steps to improve our evaluation and measurement that should help us from a compliance perspective down the line. It's not really energy efficiency, but I sort of group it with energy efficiency because it's sometimes talked that way. I mentioned combined heat and power. And anyone with large industrial customers, a number of those customers have an interest or have potential for combined heat and power. This is maybe another way to get additional value out of those projects, as well as helping the state comply. And we should be thinking about how do we best take advantage of that going forward. And then another piece, distributed solar generation fits in that as well. Right now, the state has approximately 25 megawatts of distributed solar. Probably a little bit higher than that, but it's difficult to keep current numbers on that. So that's relatively small compared to our wind generation, but it's something that customers are installing on their own, in part because we have policies that in a framework in place that's going to, at least currently, allow distributed generation to keep growing. We have some state tax credits, we have net metering, and so we'll continue to develop that as a resource unless something changes. And that's something that we should be looking at. How do we incorporate that into our plan as well? And the rule provides the state with the flexibility to do that, but the state needs to take steps and actually think about that as part of the state compliance plan. And then I just highlight a few other compliance issues. I've already mentioned a couple of these, whether or not we include new sources, how do we allocate emissions under a mass-based approach, and I didn't even talk about the Clean Energy Incentive Program, but that was something that under a rate-based approach, EPA would be giving additional credits for early action on low-income energy efficiency and renewable energy. And that's something that it seems like the state would want to take advantage of, particularly since we already have some existing energy efficiency programs. And with the production tax credit, we're likely to see additional wind on the early side. Iowa's already taken a number of steps to start thinking about these issues. So the Department of Natural Resources has led a stakeholder process. That process has met a handful of times already, and there have been different topics addressed. There's been a high-level overview, but then there's also been some of the key issues from regional transmission planning to what the federal rule looks like, to modeling results from other stakeholders that look at various compliance options, to some thinking about energy efficiency and evaluation, measurement, and verification options. So I started having these discussions, but as of right now, those discussions are waiting on next steps. DNR's plan was initially to have the stakeholder meetings that have already existed, and then to take that discussion and work on the filing that would be due this fall. As we'll get to, that filing is no longer due this fall, so we're waiting on next steps to see how the legal process plays out. This is probably the part that, if you have no background in the Clean Power Plan, you're probably aware of. It has been heavily litigated from the get-go. And by from the get-go, I mean from the draft rule, which is sort of a premature time to challenge a rule, but the folks who are most adamantly opposed to the rule filed suit to even block the draft rule, and that was rejected. And once the final rule was announced, people were very eager to file suit, so much so that they filed cases before the rule was published in the Federal Register. Those cases were rejected, but subsequently the rule was published in the Federal Register, and there is now consolidated litigation that's moving forward, and that's West Virginia versus EPA. It consolidates 39 different lawsuits, 157 different parties, and then there are also folks who are intervening and filing briefing in support of EPA. The interesting piece is the DC Circuit denied motions to stay in January of this year and scheduled an expedited briefing and hearing schedule. So briefing will conclude on the merits later this week. Oral argument is scheduled for June 2nd. We know the panel. There's some speculation that the DC Circuit panel that will be hearing the case is a favorable panel to EPA. There are lots of ways to speculate on those things. I'm not going to assume one is more correct than the other, but I'd at least put that out there. I think the most interesting part of the litigation, just from a legal perspective, is the Supreme Court issued a stay on February 9th. It's a somewhat unprecedented action if the DC Circuit has denied a stay for the Supreme Court to issue a stay. There was no explanation or basis for the stay. It was just essentially a one-paragraph stay indicating that the stay had been granted and explaining how that stay would work. It also indicated that it was a 5-4 split with Ginsburg, Breyer, Sotomayor, and Kagan, indicating they would have denied the stay. This was further complicated because of what happened later that week. And later that week, Justice Scalia passed away. And so if you were reading into the stay that it would impact the merits, the composition of the court changed. And the likelihood of a 4-4 split maybe increases. It depends what your view on how Justice Kennedy was going to rule on the Clean Power Plan. And this is just the legal standard. So a piece of that is likelihood to prevail on the merits. But separate from that is the irreparable injury standard. And one of the things that, at least I'll throw in my speculation, this isn't the only Clean Air Act case that's been litigated, and not even the only high-profile one. And the mercury and air toxin standards were recently litigated, and the Supreme Court reversed EPA in that they said EPA's rulemaking didn't appropriately take into account costs and benefits early enough in the rulemaking. It didn't vacate the rule, and the rule will likely end up implemented. But that all really doesn't matter, because after the Supreme Court's decision, it was pretty clear that most of the utilities had already taken the necessary steps to comply with the mercury and air toxin standards. And I speculate that the justices read the press and knew that was the case, and maybe didn't want that to be the case here, or at least Justice Kennedy might have felt that way, and that would have been enough for a stay. So going forward, you've got the DC Circuit arguments in June, a potential for a panel decision by the end of the summer. If the DC Circuit hears it en banc, that would be an early spring decision, or it could go straight up to the Supreme Court. So you could be looking at something as early as spring of 2017, or it could go en banc and then to the Supreme Court, and then you're looking at a spring 2018 decision, and that's if it keeps moving on a timely basis. So what that means is that the fall 2016 submissions are no longer required. Some states are still going ahead with developing their plan, but EPA can't do anything with them right now. EPA can still provide technical assistance to states, and that is going on depending on what the states ask for. And then there are things like the model trading rule and the draft federal plan that EPA is going forward with. The litigation is on track to be completed well before the compliance period. So there's a question about what the implications would be if the rule is ultimately upheld. The deadlines were not told in the stay order, even though that was requested as part of the relief that the parties asked for. And prior practice has generally been that after a rule is upheld, the DC Circuit would adjust the timeline at that point. Other implications in this for Iowa, many states will take compliance actions regardless of the stay. And that's certainly going to be the case in Iowa. We have a fairly long list of planned retirements that are going to keep moving forward because those aren't impacted one way or the other by the Clean Power Plan. We also have Iowa's energy efficiency plans that, again, they're required by state law. They're not impacted by the Clean Power Plan. And any potential new wind development, which I would assume there will be some, it's a question of how substantial that is. All of that's going to take place, some of it during the stay period, and that'll go on regardless. And then there's some amount of risk for states and utilities that don't prepare for compliance. Again, these are long-term decisions that we're making. And if you're going to rely on wind energy for compliance and you pass on building significant new wind projects because the stay is in place and you lose out on the production tax credit, that would make your compliance a bit more expensive down the line. There's also questions about what's going to happen. While the plan submission might be pushed back, the compliance date, which starts in 2022, might not be pushed back at all. And then the final consideration is, regardless of what happens with the rule, something will eventually go forward. So that's everything I've got. I'm happy to take questions, although I think I used up most of my time. So.